Everyone. I'm Monica Young. I'm the broker of Just Global Inc. and also the host of the Global Real Estate Investor Club. Welcome to another one of our monthly Zoom seminars. So for those who are tuning in on the first time today, we are the GREI Club, and we've been running events since 2003. So we do have monthly meetings that invited lawyers, CPAs, property manager, and also experts to share with you about the latest real estate update and also information you would need as homeowner as well as landlords. So basically today we are also going to give you an update about the market as well as some of our upcoming listings. Next. So as of now, I know everybody's still under a shelter-in-place mode and working remotely. And as you are well aware, COVID has taken a huge toll on the American economy. And according to the survey, more than a quarter of Americans have either failed to pay the rent or are late in the mortgage payment. So more than half of the people surveyed say that the pandemic has an adverse effect on the mental health. And for California in particular, it seems that the AB 3088 will prevent eviction due to the inability to pay rent will still be postponed until the 1st of February next year. So we are in the process of inviting a lawyer to speak about this topic as well. Next. Well, for those who have been looking at refinancing or doing a purchase, we are actually hitting historic low mortgage rate right now. So yesterday, the 10-year bond actually closed at 0.67%. And so it's been around fluctuating, hovering around 0.6 to 0.7%, in the last couple of weeks. But then 2.96 is the 30-year fixed mortgage rate, which is also one of the historical lows. So if you have not looked at refinance yet, it's the time to look at it because the adverse market fee of 0.5% that is going to be imposed by Fannie Mae and Freddie Mac will be effective by December. And for us, we are licensed also, to do mortgage. And if you want to at least check rate and compare, feel free to reach out to us. So just give you an idea, where we are. And we're seeing a very, very active purchase market because of the low interest rate. So right now, as you can see, the snapshot of the California market, say Santa Clara County in particular, where we are, we have a year-to-year growth of 6.3%, as you can see Santa Clara County. And month-to-month, we have reached 1.3 million as a median home price. And it's 0.01% lower than the last month, but still a very, very high price, even, especially with the uncertain economy. And for San Francisco, as you might have heard, because many people have been leaving the city and trying to move to a less expensive area, like suburban areas, such as maybe Truckee or Sacramento, or even Danville, San Ramon, a little bit more affordable area. So San Francisco real estate has been hit, quite a bit. And so you can see in month-to-month actually it came down about 7.8%. But year-to-year it still have a 4% increase. And overall speaking, we're seeing a lot of buyers in the market because of the low interest rate. So talking a little bit further about commercial, next. So we are actually looking at the commercial holding. One of the reasons is I do have a number of clients doing 1031 exchange. So because for sellers, it's a good market to sell because we would have multiple offers. And also a lot of first-time home buyers are entering into the market. So there's a lot of interest out there. When they sell, they might be looking at exchanging into commercial property. So we're talking about say apartment, say such as the apartment being a C grade, only come down slightly, negative 1.3%. And also for apartment class A is negative 1.6%. On the other hand, say if you are looking at warehouse because of all this e-delivery. The people are ordering goods online. Warehouse become quite popular. And if you're looking at maybe buying really at a good discount, then you probably would be looking at retail and hotel, because hotel actually, you will have a slide that show you right now that's 50% vacancy on hotel. And a lot of the mall, and I heard the commercial brokers told me, like 50% of the street mall and commercial mall, the tenants are not paying rent. So it's very significant. Next one. So this is like a little bit look ahead in terms of sales price and commercial price outlook. You can see that for land, it would not have like too much of an issue, because like a lot of builders may be holding land so that they can build at the next high point. So land is still in demand. And of course, it depends on city. Like say, we've been selling, of course, in the Bay Area, and also we have clients invested in out of state like Austin. So Austin land actually is very, very highly seeked. And then in terms of like other groups, you can see that warehouses is going to be quite stable. And if you're selling a single home, buying into duplex, triplex, fourplex, it might be a good time, because like the apartment B and C grade, they're still in high demand. The price slightly adjusted, but not significantly. But if you're looking at buying a triple net, say, you know, I've been talking to clients, say, hey, oh, property type, you know, such as, say, if it is a CVS, Walgreens, they still, you know, like out for sale for about like 6 or 7% now, which is very high in terms of cap. And then Dollar General, Dollar Store, also in highly seeked. But otherwise, you know, like if you're looking at strip mall or office and those, you know, we probably would suggest like probably put a hold on it, because it's not going to be the right market for it. Next. So you can see that, you know, when you're a landlord, you're looking at vacancy. So by far, say if you have like a multiplex in the Bay Area, your vacancy should still be quite low. We're talking about 5 to 7%. And if you have a Class A property, because your rent is so high, some of the tenants might move back with parents, or they may be flying to Denver, Colorado Springs, or maybe Austin, Texas. They might try to maybe get cheaper housing there. Rent is lower, and also housing is lower. And on the other hand, say a lot of the high-tech employers such as Twitter or Facebook or Google now allow their employees to work out of home, either indefinitely, like Twitter already said, you know, 100% can work remotely. And Google and Facebook actually, they kind of looking at to at least next August or end of next year that the employee can work from home. So the office demand is going to be slowing down. So just give you an idea in terms of the vacancy rate. Next. So for in terms of forbearance, so you might have heard that a lot of people, because 20 million people are now unemployed, and the forbearance rate is actually increasing. Just in May alone is 7.3%. As far as we know, nationwide, and 19% of people are not paying mortgage. They're in a forbearance status. That means, you know, the especially loan by Fannie Mae and Freddie Mac that allow them to stop paying mortgage, because either that they lost a job or they're not collecting rent from the tenant because of the tenant rent moratorium. So by end of this year, you know, they already extended to end of this year, but very likely would be going into the first quarter of next year. So we expecting more short sale and forbearance will be coming out by the second quarter of next year, because people have to start paying their mortgage, or else they have to put it on the market to sell so they can get the equity, or they have to do a short sale or foreclosure. So there are some trends, but it may or may not be exactly in the Bay Area, but some of them may be in the Bay Area, but more of them may be in other cities. So we're going to tell you which are other cities that would see more foreclosures. Next. So at a nationwide number, by far Miami already, you know, a lot of condos, high rise, they already have a lot of inventory. So 14% of the people are not paying the mortgage, they're in forbearance status. And right behind it is New York, it's about 12%, and Vegas. Vegas also because very, very hard hit because of hospitality industry. A lot of the casinos and restaurants laying off their staff. So about like 11% people are not paying mortgage. And whereas in San Francisco, we have about like 5% of the people are behind. So just give you an idea, cities where you would see, more discounted property coming up because some of the people who are in financial distress are going to put their real estate property on the market. Next one. So in terms of like sales, actually in the Bay Area, because of the tech job, so far, I think, especially in the South Bay and Mid-Peninsula, we are actually seeing the tech job, the professionals are being able to preserve their job. And then we actually seen some of the high price property that have like quite a strong growth. You can see like property over 3 million, they actually have sales just went up 76.6%. In fact, I've been bidding on property, like in Sunnyvale and Cupertino with good schools, and now the property price would be between the range of about like 2.5 to 3 million. We've seen anywhere about like 4 to 10 offers for the properties that is well located at good schools. So you can see that because of the low interest rate, a lot of people are still buying, and typically they would have a high down payment, say $1 million or more than $1 million, and they would carry a loan at like 2.5 to about like 2.875% for jumbo loan, which is a very, very attractive rate. It helps to lock in a good mortgage and make it, more affordable to buy. Next. So we're talking about the new normal. A lot of people will be working remotely because like statistically, 3/4 of people work from home now say that they want to continue. And 2/3 of people would say, hey, they would consider moving to a less expensive area if they were given the flexibility. And remote working will promote home buying in secondary city, like I mentioned about, such as Austin. And even Vegas, you can see actually a lot of California are moving into Vegas because of the low housing costs. Some of them are retirees, some of them may be looking at working remote for a year or a few years. And then also for the people who would be more open to commute to be a little bit further away, because I do have clients buying in, say, Castro Valley, Danville, even Brentwood, because now the company only requires them to go back to work in the company 1 day a week instead of having a daily commute. So this kind of changed the home buying pattern. So as a real estate broker, we've been very busy. So like I can show you what we've been, put into the contract and sold. So this is a home in Milpitas with decent, nice school. We're talking about like a 9, a 8, and a 10, for elementary and up to high school. So we got over 20 offers. We listed at 1.688 and actually closed at 1.35 with over 20 offers, just pending within a few days. So we also put into contract, next one, and a number of properties. So like Mountain View, in fact, we'll have an email out. We have like clients who work for Google who just reserve a property. It's brand new townhome for $1.56 million for a 2-bedroom, 2.5 bath, about like 1,300 square feet. So, it's very, very popular now still, new homes selling like hotcakes. And they have like the 3-bedroom available, which is actually in very nice area. It's about like $1.75 million. And then also we have put in contract new homes in Fremont, 1-story for about 1.5. It's very nice. It's very, very seldom that you see like 1-story new home. So if you got a chance, you should really consider something like this, because otherwise you have to custom build one. And then we also encounter multiple offer in South San Jose. This one actually is very competitive, 13 offers. So asking for $875, and with 13 people bidding, and half of them are cash buyer. So you can see that, the market still, a lot of people with cash. And then also with upcoming listing, next. So we have like a few listings coming up. You're welcome to contact us if you're interested in any of this. This one will be coming up in about 1 to 2 weeks. This one is in San Leandro. And my client actually, they just sold they actually moved into a new home. They buy first and then sold later. They moved into a 4,000 square feet home in Castro Valley. and they're going to sell this 2,400 square feet home in San Leandro. It would be targeted about 900,000, which is a very good size home. If you, in case you think, hey, I want to move a little bit further and want to buy a good size home at a good price, I think this is the one you can consider. And next one. So I have a client who's planning to sell a duplex in the Cupertino area with Cupertino School, and is very close to the Apple Spaceship Campus. We essentially 5 minutes drive. So 3-bedroom, 2.5 bath on one side, the other side is 2-bedroom, 2.5 bath, and asking for about $3 million. So it's good to live in one, and you can still collect rent on the other, which is a very, very popular mode right now. And this is in Cupertino School with Stockmeyer and also Cupertino Middle. Next one. So this one is actually my client, again, you know, like for empty nester or people who have kids about to already, you know, like graduated or leaving for college. And many of my clients are trading down. If you want to sell your own home in a good school area, like this one is in a mission school area, and the parent, actually a lucky parent, the kid is going to graduate very soon. So she wants to get a home that is newer and maybe, you know, like capitalize on the appreciation already. As a good size home in Mission School District, walking distance to the Mission Elementary School, a very well located home. And so she may be moving a little bit, you know, like closer to shopping and have a bigger, newer home. So anybody interested can talk to us, because this homeowner is ready to sell, you know, anytime. But otherwise, we'll put it on the market for starting in January. And if you have any question, next, please. So please look at it. You know, the next one is the San Jose home. The San Jose home actually is very nice to have a detached garage. And detached garage now can be turned into ADU. So I actually have some contractor who quoted me a rate of turning a detached ADU as little as $80,000. Detached garage into an ADU, and you can collect rent, because basically you have like electricity and sometimes water available. So turning a detached garage into an ADU may be a good way to get some extra rental income. So this is going to be the trend. A lot of homeowners are now building ADU or converting ADU because of the latest housing need. So this one you could also talk to us. Is in Cambrian area. It's about like 1.2 million. So I have included our contact, and I think many of you will know us. I'm Monica Young, and this is my phone number in case you want to talk real estate or want to get some latest quote on mortgage. You know, we'd be very happy to help you. And so call my associate, and we have other associates that we're working with. So we work as a team, and we are very active in the Bay Area and also investment market. So we welcome you to reach out in case you have any questions. Okay, so that wrap up my first part of our presentation. I'm going into my speaker, the featured speaker for Mr. Michael Lee. Hi, Michael. How are you?
Hey, Monica, how are you?
Yeah, so great. Thank you very much for standing by. So Michael is the managing partner of Rue Attorney, and it is a Bay Area law firm specializing in estate and tax planning. And the primary focus of this company is structuring wealth management services for families and also promote tax efficiency. They are very, very competent, and they are able to handle complex real estate transactions as well as asset protection. So welcome, Michael. I'll pass the floor to you.
Well, great. Thank you, Monica. Thank you so much for the invitation. And I loved your slides. You have some beautiful properties there. Gosh, they were really something. There's some great things going on. And that's the kind of interesting thing that we're seeing right now with this pandemic is that there's kind of a joke, and it's kind of funny. American people tell it a lot, and I don't know how accurate it is in Chinese, but American people often say that the character for crisis and the character for opportunity in Chinese is the same character. It's a common idiom in English. Of course, English people say this. I'm not sure if it's accurate in Chinese, but it's the meaning is kind of interesting, is that sometimes when there is crisis or there is change, it's the best time for opportunity, because when there's a lot of change, you can catch what's happening. And as Monica was talking about things in investment in real estate, we're going to talk about things for change for your estate plan and the arrangement of your financial affairs in a legal aspect. So we'll be taking a look at that. So Carl, if you could put us to the next slide. So a little bit of a roadmap for what we're going to be talking about today. We're going to be talking about 5 different things. And then we have a chat box, and we have a way to provide questions in the chat box. So if you have questions for me, that's a great way for you to ask questions and while I'm talking. And then we're going to have some time at the end where I'll address the questions. Sometimes if there's short things, I can pop in and answer, but generally we'll leave them to the end. So what is our roadmap? What are we talking about today? We're going to go through 5 general areas, some a little bit longer than others, some a little bit shorter. But the first thing what we're going to talk about is why is estate planning especially important during this pandemic time that we're living through? What considerations should investors be aware of due to the pandemic, and how does this relate to estate planning? Third thing is we're going to talk a little bit about property tax and how to minimize property tax reassessment to heirs. This is a common problem that I see in designs of estate plans. Number 4 is how can investors ensure their real estate is properly managed if they're ill or incapacitated? We'll talk about that. And then number 5 is always a big topic, estate or asset protection planning. I'm actually going to tell you about a new law. I rarely get to do this of having a new law, but there's one, and it's coming. It's going to come down the pike, which we'll talk about asset protection in California. So that is our path. So let's look at our item number 1. So our pandemic and planning. So let's take a look at the next slide here. Great. So we're going to spend a little bit of time on this one. So I think the first one is the obvious things of the pandemic. What is the pandemic? It is a global health crisis. So of course, estate planning has come up to sort of the fore for a lot of my clients. Clients that I've talked to about estate planning 2-3 years ago, and they said, we'll get around to it, we'll think about it. All of a sudden say, I need the earliest appointment, I have to get in immediately. So the health crisis has made us more aware of this. And really we should be thinking about it kind of in 3 parts here that I have. So the first thing I think to think about is, do you have a plan? And many of you, I'm sure, are sophisticated as having the estate plan is if something happens to you, one passes away or one loses capacity, do you have a system where you can avoid the California probate process, the California court supervised process to administer your assets, or if one has dementia or has limited capacity, administer you? Do you have a system to avoid that? And so the plan generally consists of will, trust, power of attorney, healthcare directive. I think everybody already knows that. Where do I see problems? Common problems. Is the plan funded? Lawyers, we call it funding. Did you actually record the deeds? Did you actually put the real property into the trust? I get cases every year. I usually have 2 to 7, sometimes heavy years, of where people say, I have a beautiful trust, I have a beautiful will, I have all of this stuff. It's empty. They never put the properties in there. They said, oh, the lawyer just said to have me sign all of this. And they said, I need to go figure out with the deeds. And, I never did. That's a big problem because if the deeds aren't inside the estate plan, it's an empty plan. It's not going to administer those properties. The other thing people forget all the time are large brokerage and bank accounts. So large brokerage and large bank accounts often get forgotten as well, is that generally those also should be titled in the name of the trust. So your large savings account, large brokerage account, title that in the name of the trust. And your day-to-day account, you just keep the balance under $150,000. Technically, the rule is about $166,542, something thereabouts. If it's below that, you can use an affidavit to transfer. So generally the best way is large accounts, title in the trust. Small accounts, just leave out. And of course, with online banking, they're connected, very easy to move money, and a very safe strategy for making sure your trust is funded. Also, it's important to make sure your schedules, there's usually schedules in the back of your trust that list property. If you have things that are important to you, jewelry, items like that, it's important to schedule them. It's also, I don't have it on the slide, but it was a question that was posed to me. It's also important if you own closely held businesses, an LLC, a corporation, to make sure that you assign your membership interest, assign your stock into the trust, and here's another commonly forgotten area, make sure your operating agreement or your corporate bylaws match your estate plan so that if something happens to you, your spouse or the other person is automatically a member or automatically a shareholder rather than just an assignee under the business docs. So something to take a look at. Make sure you have a plan, make sure it's funded. The other thing a lot of people that have this crisis has spurred is to take a look at, does my plan still work? Is my plan up to date? Since around 2005, the estate tax has been changed about 4 times in major upheaval, restructuring transformations of the estate tax. So older trusts, especially Bay Area older trusts, I would say anything before 2013 and definitely something before 2010 is going to be structured in a somewhat odd way because of the way the estate tax looked prior to 2010. Remember, back in the early 2000s, the estate tax exemption was $1 million, 1 million. So you have these trusts that often, if something happens, it creates all kinds of division trusts and some very odd designs in there that was very appropriate in 2003. But now in 2020, 2021, and in the future, don't really make sense because the law was changed in 2017, changed in 2013, changed in 2010, that it just doesn't look right. The other thing is to take a look at is, are your trustees, if something happens to me, the trustee will take over. Are they up to date? Have children, let's say sometimes people will do their trust 10 years ago. The child was 10 years old. Now she's 20. Now maybe she can serve a role. Maybe she should step up. Are beneficiaries current? Are all new babies added? Is everybody in there? Make sure that's added. And like I mentioned before, make sure your assets are current. And I have the second portion here is your plan, though, COVID up to date? And this has changed a little bit because I always used to say you have to have your plan updated, but actually, is it also up to date COVID-wise? One of the things that's becoming quite a problem is, does your plan rely on trustees or people who are very far away, who are not easy to travel locally? So I've had often some concerns of people that are updating, especially things like healthcare directives, powers of attorney, things like that. And they say, well, initially when I did this, I named my sister or my brother to be my power of attorney holder or the advanced healthcare directive holder, but she's in Grand Rapids, Michigan, and if something happens, there's no way that she's going to be able to get over here quickly, just a reality of the way things are working. So the other thing to think about is with your plan design is it designed in a way that is easy to administer? Are people local? Are people able to travel? This is compounded with people who have international plans or international issues in their estate planning. Anyone may know, if you are not a Chinese citizen, you essentially cannot travel to PRC China now. Even if you are a Chinese citizen, you're quarantined for 14 days. International travel is 1,000 times more complicated than domestic travel. Does your plan have something where people have to move around to come and administer things? That's going to be a problem. Also, I see this problem fairly frequently in a lot of my estate plans is there contact information for the beneficiaries and the trustees and all of these things, is that they'll say, I named John Smith, my brother, as my trustee. It's like, did you give his email or phone number or some contact information in the trust? Because people are going to have to figure this out. And people are going to have to start contacting people. So that's a quick tip that I recommend in everybody's estate planning folder and binder. Make sure everybody's email, telephone, last known address is updated in there, because if anything should happen, it needs to get, people need to get in contact with each other, and having a nice one-stop shop to take a look and know everybody's contact information is very, very, very helpful. So the last thing I mentioned, again, with the obvious, is that is also a common problem, and I see, is that I say, is everyone included? And the question is, I often talk to clients and they say, yes, 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 and I have a great estate plan, I've funded, I've done all of those things that you say. And then I say, okay, what about your parents? They say, oh yeah, they live in Cupertino, they've lived there a long time. I said, did they do the same thing? And people say, oh, I don't really know. I haven't looked. I'm kind of uncomfortable to ask, or something like that. And that tends to be another problem, because I have had a number of situations where the parents' plan and the grandparents' plans were not really well coordinated, and they didn't really work well together. And that's one problem, especially with trust and will planning. The other thing is, I often have people make the sort of misunderstanding or misconception. They say, "Oh, my parents, they don't have anything. They don't own a house. In fact, it's the house where they live. They rent it from me. They don't have they don't have any substantial accounts. They don't need any estate plan. They don't need any estate plan." And I say, "Oh, that's going to be a problem. Trust maybe they don't need, but power of attorney and healthcare directive, that's going to be a potential problem that can come up. Is that as they get older, and one wants to assist them with just ordinary financial affairs, they're going to need to grant you a power of attorney to make sure that everything that you do is legally recognized and proper from that aspect. The same as the healthcare directive. Having the healthcare directive can be incredibly helpful because you can then work and assist them with their healthcare needs and things like that. So a lot of people forget that. They think, oh, they don't have any major assets. They don't need any planning. Of course, maybe that's they don't need a sophisticated trust, but a document to allow their relatives to help them on some things can be very, very, very important. And this same problem occurs. I had one of these. This actually just came up just a couple months ago, of a problem with co-owners of property, in addition to, of course, yourself, your relatives. Sometimes it's important to ask if you own property with someone else. It's not in an LLC. Let's say you just own as tenants in common in a property. Just to generally say, have you done an estate plan? Have you done something? Because if something happens, that half of the property is going to get tied up in probate, and I'm the other owner, and of course, I'm not going to have to pay the probate fees or anything, but I'm going to have to be stuck while that all happens. And it would be nice if we kind of figured out something to do to make sure that we don't have a problem. Of course, they can do an estate plan. You can have a tenants in common agreement. You can do an LLC. You can do all of these things. There are a lot of ways to solve it, but that's the sort of the three obvious things to take a look at for this global health crisis. What about the less obvious things? Let's take a look at the next slide. So now it's going to our crisis can be opportunity. There are a couple of things where this pandemic has caused us to think kind of on a next level, besides the obvious of okay, it's a risky situation. Okay, what can I do? One of the things that has been really important that people have been thinking about in this pandemic situation is the advanced healthcare directives. A lot of clients traditionally did not prepare these, or they were relying on the ones produced by their hospital, which is just fine. But if you rely on the one for the hospital, they're a little bit vague. They're fine to grant an agent, but generally you also want to have a backup of one that's drafted, that's sort of your catch-all healthcare directive. And your healthcare directive, of course, can do two things in California. And just to back on the healthcare directive, these get called a lot of different things. California calls them advanced healthcare directives, and healthcare is two words. Some states use healthcare as one word. Sometimes they're called living wills. Sometimes they're called advanced directives. Sometimes they're called all of these different things. But in California, it's the advanced healthcare directive, and they do two things. One is you can set your healthcare agent. You say, I choose this person and that person if I'm incapacitated to make healthcare decisions for me. And you can leave it there. You can just say, I trust that person's judgment. Interestingly enough, mine is that way. I don't express healthcare preferences because I talked to my agents and they said, I really don't want to be constrained. I don't want to have this feeling of that I should go one direction or the other. I think I'm capable enough to make a decision, and I agree. And I say, yeah, I don't have healthcare preferences as part two. But the Advanced Healthcare Directive law allows you to express your healthcare preferences. So if you have strong healthcare preferences that you say, I wish to be kept alive in all situations, you can select that. If you say, if I'm in an irreversible coma, or if the detriment of treatment outweighs its benefits, I do not wish to receive that treatment, you can express that. Probably, I always tell clients that with the consent of my client because they're an enjoyable client. The most complicated one of these I ever drafted was for a couple who were Haredai Jews, very traditional Jewish persons, and they have very, very strict religious preferences on healthcare and interment, and they had probably the longest and most complicated healthcare directive I've ever drafted. But the reason I tell the story is that we can tailor it for as little as you want, as just set it to an agent, or if you have very specific preferences, we can do that. And of course, as I mentioned before, you need them, your husband, wife needs them, your grandma and grandpa need them, parents need them, and who is always forgotten? Who is always forgotten? I see this all the time. What about your college-age children that have gone out? What if they're away from home? What if they're, they've gone to college and they're 19 and something happens? They're an adult. You can't rush into the hospital and say, what's happening to my son? They say, he's an independent person. Are you on the emergency contact information? When he was checked in, I don't see anything. He came in an emergency. I don't know who you are. Go wait out there. We'll tell you later. And actually, we're not going to tell you. It's if he walks out. That's a big one that I see forgotten all the time, is that perhaps you're talking to adult children before they go off to college. Say, we should probably do a healthcare directive for you, just so you can set mom and dad to be your healthcare agent. God forbid something happen. But this is one of the common ones that I always see where people think, oh, I don't need a healthcare directive for 19-year-old daughter, 19-year-old son. I say, we hope we never do. But that can be a very uncomfortable situation where the person, especially 19, 20, 23, 25, they're a full independent adult. And without a healthcare directive for that person, you cannot easily get access and know about healthcare situations. So that's a common one that I see forgotten all the time and recommend, because most people can think about themselves. Sometimes they think, okay, my mom and dad I got to take care of. But the college-age kids, people often forget. So that's the healthcare directive. The other thing that I've been seeing a lot recently, which is an important estate gift tax issue, is the payment of tuition and the payment of medical expenses for others. And I get always some questions about this each year, about whether or not it's taxable either on the income tax or the estate tax or the gift tax, on and on and on. So there's a special rule for this with Revenue Code 2503, and it should be small e, not large e, actually. So if you're going to give either tuition payments or medical payments to a relative or anybody, to anyone, to avoid income tax, so it's not income taxable to them, so it's not subject to gift tax or a problem with the estate tax, you can pay tuition for children, grandchildren, friends, relatives, however you like, you can pay it and avoid the gift tax issue, but you have to pay it directly to the institution. I frequently see this as a problem where people will set up and they'll have the grandson's account, and they say, oh, I just put in into the grandson's account, or often I see it as a joint account, and they'll say, I just put in $5,000 every month, or I put in $3,000 every month, and the school takes it out of that, and they just take it out of that joint account like that. And I always tell them, that's the wrong way to do it. You can do the account, but don't have the person on that particular account. The way you have to do it to avoid any gift tax or estate tax issue is you have to pay the funds to the institution directly. So you can have an auto withdrawal on a segregated account to pay for private elementary school, private high school, pay for college, pay for trade school, pay for all of these things. You can completely do that. But what you don't want to do is be giving straight checks or giving transfers of funds to the person, to the beneficiary, because that technically does not fall in 2503, that unless it's fitting into the annual exemption, the annual $15,000 per person gift tax free, it's going to exceed that. So I always tell people that, especially if you also have, let's say, a life insurance trust, you have to make sure you do it this way, because you're probably using that $15,000 exemption for the life insurance trust. So tuition, pay directly to the institution. Same for medical, pay directly to the institution. Pay Kaiser, pay Sutter Health, pay them. If you pay them directly on behalf of someone else, there's no gift tax consequence there, no income tax consequence there. The only restriction for medical, though, is you can't pay for elective plastic surgery. So if you have a dear friend or relative and you say, oh, do you want to take care of that? I'll pay for it. That's actually going to be considered a gift if it's elective plastic surgery. If it is not elective, if it's corrective plastic surgery, completely fine. But elective is no-go. The last thing that we also should think about in this crisis can also be opportunity is we're in a weird time, not just because of the pandemic, but we're in a very weird time for the estate tax exemptions right now. So the estate tax exemption, the federal estate tax exemptions right now are about 11,600,000. It's thereabouts per person. So a married couple, let's say, has about 22 million, 23 million for estate tax exemption. That's great. That's great. Very high exemption. The problem is it sunsets. It ends December 31st, 2025 at midnight. So the problem is, and I've heard CPAs, I've heard a lot of lawyers sometimes make errors on this, saying, oh, you don't have to worry about the estate tax. Look, it's $11 million. I say, well, yeah, you don't have to look at that if you plan to die before 2025, which I don't. I plan to live long, long after 2025. So, and all my clients do too. So they actually do need to take a look at what's going to come next and figure out what the opportunity is. What's going to happen after 2025? It's going to drop down to 5 million per person, adjusted for inflation. So we're going to be back under the pre-2017 slate of exemptions. So that's fine. We can work with that. But if you are a large estate, you should really consider strategically using the 11 million now. You have to use it all. It's an all or nothing thing for large estates. But if you're a large estate, you should really be considering exemption planning right now because we have a very high exemption. This is actually the play. When the Internal Revenue Service created this and the drafters of this created this, they did not create this for people passing away. They created it for using the gift exemption for very, very large mega estates to gift things strategically over a 5-year period. So this is something, if you're a large estate, take a look at this, start contacting us and your advisors because you'll want to use this if you're a very large estate. There's a narrow window. The other thing that's been very good, and Monica touched on this also, and this is true not just for institutional loans, but for private loans, very, very, very low interest rates, shockingly low interest rates, best rates we've had for some years, even 50 years, great interest rates. And the applicable federal rate, this is the rate for sort of private loans, intra-family loans, business to owner loans, those sorts of loans are now very low. So the IRS is having the setting the rate for some of these loans. Some of them are down to 1%, 2%, very, very low loans. So what is this? How can this be used for slightly larger estates or complex estates? Intra-family loans can now be done at very, very low rates. You can move money from one generation to the next via a loan system at a very, very low rate. You can sell property into irrevocable trusts at a very, very low interest rate. So what does this mean is we have a high exemption, the first part, high exemption, so we can move things around easily. And we also have very low interest rates. We can sell things and move them around very low interest, very inexpensively. So transfers to irrevocable trusts or loans from one's personal company can be done at a very, very low rate, which a few years ago, you'd probably think, the early 2000s, it was quite expensive to do this. The applicable federal rate back then was very, very high. Now we have an opportunity. So some things to think about there. So let's go on to our next topic, number 2. So this is our COVID investors and estate planning. We'll just spend a little bit of time on this one. So let's go to the content here. So co-owners, we talked about this a little bit before, is owning property, especially if you own single asset real estate with others is kind of like a marriage. And you, for better or for worse, whether the good tenant or bad tenant, whether the plumbing is functioning or the plumbing is not functioning, you're arm in arm with your co-owner. So one of the things to think about with the COVID, investors, estate planning, all this is you do have to think about your succession planning, incapacity planning with regard to the things that are co-owned. And think about is, okay, we own this property, make sure, do we have the property arranged in a way either with each side owns the half in trust, and then make sure that there are powers of attorneys, or do we own the thing together in an LLC? Do we have emergency provisions or a provision on how management changes if there's an emergency? The same for a corporation. Sometimes I've seen some strange things out there. This is the first time I saw this year, people who co-owned, they are not related parties, and for some reason they had a joint tenancy. Joint tenancy means whoever passes away, it goes to the other person. That's not at all what they intended. We had to do a severance, but somehow they ended up with that. So definitely something to check when you own things with co-owners. Make sure not only do you own it title-wise, as tenants in common, make sure you have the structure to deal with if there's some issue of incapacity or passing. And this can be done as either two trusts, it can be done as a co-tenants agreement, it can be done for the appropriate property LLCs. You can do all of these things. So those are all options there. So going to acquisitions, this is just one thing I'm just going to kind of breeze by. Acquiring property or putting property into trust. The county recorders have been super slow recently, but not terrible. Notary services have been a little bit difficult, but our office, we have internal notaries, so we haven't had a problem. And the other thing is that you probably have seen, those of you who trade real estate recently have probably seen this, but those who don't do it as frequently, in 2018, there's a new deed surcharge, $75 for non-primary resident deeds. Recording a lot of deeds has now become expensive. So that's just something to take a look at with estate, will, trust planning, working with your attorneys, of ways how to, of course, record deeds. But if there are situations where you need multiple deeds, such as converting joint to community property to the trust, sometimes that joint to community we can do via a marital agreement and avoid having to record a bunch of deeds. So that can be a strategy there. So let's move on to the next slide. We have some more interesting things coming up. Maximizing property tax. This one's a big topic, but I want to throw it out there, and then we'll do questions as we go through. So let's go on to the content slide here. Move a little bit faster. I always get a lot of questions about this, and it's a real common problem in trusts that are not super well thought out or are done a little bit sort of boilerplate, where the lawyer just sort of prints out a standard trust for you. You have to understand California Propositions 1358 and 193, and this is very important for people who own real property. And in fact, it's critical because these are the real property reassessment rules. So the thing to think about is this, is sort of the basic framework. Prop 58 transfers parents to children or children to parents. That's exempt from property tax basis reassessment. So your property tax basis assessment you can keep if it's parents to children or children to parents. Prop 193, this one's more complicated. Real property transfers from grandparents to grandchildren are exempt from reassessment if the parents are deceased. This happens all the time. Remember I said on slide 1 up there of coordinating your plan with your parents' plan and making sure there's not a problem. This is a classic potential issue here of a situation where the grandparents say, oh, well, what if I just give the grandchildren the real property? What if I just drop it down to them and I'll bypass my children? Under 193, that's going to not be exempt from reassessment. That's going to be a change of ownership because on the form, the Prop 58, Prop 193 form, it asks, did the grandparents have any children? Okay, yes. And then they'll ask, well, what date did they all pass? Because they all have to be deceased for the assessment to go down to the grandchildren. So you have to be a little bit careful with this planning if you're going to do a skip. So this is something where, again, we have to coordinate the parents' plan and the grandparents' plan so that we don't have problems there. The other thing to think about, to drop down a little bit, is what is exempt from reassessment. There are two parts to the exemption for reassessment. One is the primary residence. The primary residence can descend down from parents to children or grandparents to grandchildren. If there are no parents, it can do either of those things, and there's no value limit. You could have have the assessment at $50,000 and it could be a $100 million property, no problem. It doesn't matter at all. The other thing is for other property. Okay, I have the primary residence and we have the La Jolla beach property that we've always had, the little beach cottage up in La Jolla. That can also be sheltered from reassessment up to a value of $1 million. So if the property I bought at 500 and it's now worth $1 million, no problem. I have $1 million of exemption, so to speak, that I can just stick there, and that can be shielded. So this works for primary residence and for maybe a rental property or something like that. Generally one, maybe two, but not more. Not more value than $1 million. Where are the classic major critical problems that come up? One is, always remember, when you place the property in the LLC, that destroys the ability to keep the property tax reassessment for heirs. The Board of Equalization is very, very clear, and they've had a number of rulings on this, that if I am the heir and I inherit a property held in an LLC, they say you did not inherit the property, you inherited the LLC membership interest, and there's no exemption for LLC membership interest. So you have to be very cautious in using LLCs for rental properties, because if you're hoping to keep the tax basis, because it keeps the economics of the property in good order, because you say, oh, with the low property tax basis, good renter, inexpensive insurance, this is really cash flow positive. You have to be very careful with the LLC, because the LLC may change the economics for the beneficiary, because it will be reassessed, because the LLC does not work that way. So when do you use LLCs or corporations for properties? You usually use them for commercial when you have a triple net lease, because then when the property tax gets increased, it's not the owner's problem, it's the tenant's problem. With COVID, now every tenant problem is now the landlord's problem, but that's the traditional way to do the planning. The other thing to be aware of is it does not work among siblings. So if you have a structure where you say, okay, we have 3 properties and we're going to give each child a third of each property, so they're going to have 1/3, 1/3, 1/3, 1/3, 1/3, 1/3, like that, that may not be a good idea, because when they take those titles, if they took title that way and they want to transfer it amongst themselves, it's going to cause reassessment. It would be better by giving property A to Sally, property B to Sam, and property C to Sue, and give them whole titles. That would be generally avoid the problem. The other thing is the trustee, depending on if the trust is well drafted, the trustee can use what's called a share and share alike provision. The trustee can administer that as well. The other thing you can also do, which is very useful, is if you just have one property and you say, well, one child, there's the 2 kids, and they each, I want to be fair, I want each 50-50, but I think Johnny may want to buy out his sister. If you don't have any special provision in the trust and he tries to do that, it's going to cause a reassessment of the property tax for him, which is really bad, because he's probably, if he needs the property to buy out his sister, he's probably economically, doesn't need more expenses. So what do you do in the trust to structure this? You give him an option. So you say that the children get the house 50-50, but Johnny has an option to buy from the sister. The BOE says, if you give him the option, we will consider that he has a right to the whole. We will not reassess. So it's a very clever thing to do, to add into trust if you have just, let's say, one property and you want to do an equal distribution where one child buys out the other child, give the buying out child an option. The BOE loves this. The BOE has a published opinion. The BOE is like a court, oddly enough. And the BOE has said, that's what we want you to do. If you grant the option, we won't reassess, and just basically attach that opinion and attach the trust that has a copy of the option, and we'll say, enjoy the low tax basis. So just some things to think about when you design the trust. You know, us, you know, of course you can rely on, but, you know, other attorneys, make sure, ask, you know, how much do you know about property tax reassessment? Because sometimes they don't know anything. And you can have these really odd plans that cause these property tax reassessments. And the sad thing is once the property gets reassessed, let's say in an LLC or something like that, it's forever. You're stuck with that assessment forever. There's no way to get it back down, unless there's some massive economic collapse, you know, which is, you know, that's going to be a problem all over. So that's the thing to think about, or some little tips about property tax. Let's move on one more slide here. Perfect, and we're right on time here. Last thing, asset protection. I'm actually going to be very, very brief on this. And introduce something I rarely get to do this, and it's exciting for me, to introduce a new law, a major sea change that is coming to asset protection planning and really the debtor-creditor landscape of California. And this is the amended California Civil Code of Procedures 704-730A. What is this? This thing's called the homestead exemption. So what is a homestead exemption? A homestead exemption, every state has some type of this. And the homestead exemption is essentially, per law, it says an amount of your home equity is immune from judgment creditors. Not the IRS, they can't do anything about the IRS. But let's say you have one house and you get sued. The homestead is what says, okay, there's a certain part of your equity that the creditor, you could lose the lawsuit and you have the judgment against you. The creditor can't do anything to pull that home equity away from you. There are some techniques that can make life very difficult for you, but you have this guaranteed amount that is going to stay your value. Traditionally, before this new amended homestead exemption for California, the old law, which people have, you know, California lawyers have known since the 1920s, the California homestead exemption, the last one that we had, individual, your homestead exemption was $75,000. Married couple, $100,000. California, you know, $100,000 for a property. I mean, it's insane. So with the you know, this $100,000 exemption, we had very, very low homestead exemptions. The homestead was really not usable. The new law changes this by a factor of 3 and 6. So under the new law, the California homestead exemption is going to be $300,000 or the countywide median sales price for a single family residence not to exceed $600,000. As you saw Monica's slides, the median home price in Santa Clara County is way larger than $600,000. So for us, for most Bay counties, our homestead exemption is going to be $600,000, 6 times larger than what it used to be. So now, just thinking about asset, this has changed sort of all of my asset protection thinking, because we used to have a problem in California that our homestead exemption was worthless. Now it's going to be likely very, very useful, because in your primary residence, if you have $600,000 worth of equity, it's going to be safe. Before, it used to be very, very exposed. So really, this is the thing that we're going to start doing some planning, where a lot of times what people will do is that they will prime their primary residence with, or we call it an equity strip structure. The house is in a revocable living trust. You don't need anything else more. You have your first deed of trust, for whatever you owe on the property. And then oftentimes maybe you will have a home equity line, but you won't draw on it. It's your emergency valve equity strip. And that's basically what you do is in your stack, you have the value of your house, you have the first deed of trust, and then above your equity, you want to keep $600,000 or less. You can keep more than that, but you have the home equity line, if something goes badly, you draw on the home equity line, and then you use the home equity line to fund your legal expenses or to do whatever you need, and your home equity is protected because you keep, less than $600,000 in home equity. So there's a lot more techniques that we're going to have. This bill passed in the Assembly, passed in the Senate. It is literally on Governor Newsom's desk, so it's awaiting a flick of a pen. So I think, is it law today as I speak now? No, but this by Governor Newsom will make it law. It's quite interesting and quite amazing that this passed. Years ago, this was very, very controversial, and it seemed like it would not be possible. Now it seems like it's going to be a matter of days. I'm literally on the California State Legislature. I have a flag on this thing, so as soon as it gets signed, I'm going to get an email. So I look forward to letting you all know once it becomes the law. But this is going to change a lot of the landscape. Another thing that on the other side for you, we'll also have to think about it the other way for everyone listening, is it will also change the creditor landscape. Now, if one lends money or one is doing some business transaction, someone saying, oh, don't worry, I own a house, that may not be an asset that is of recourse. That used to be very common in California, that if you're going to do some private commercial transaction or private lending transaction, the person said, oh, I own a property, and you looked and said, oh, they've got a little bit of equity, you felt pretty safe. Now, with the $600,000 exemption, that's probably immune from anything that you could get, unless you do a deed of trust and you actually perfect on that property. Consensual liens aren't affected by the homestead. Those always take priority, but something to take a look there for if you're doing lending transactions. It's going to be a little bit different than it was before. So we're starting to become a state that has much more generous homestead exemption than we used to. The most famous one, a lot of people I think are familiar with Florida. That Florida exempts based on size, so they exempt a quarter of an acre. And it doesn't matter whether it's a quarter of an acre, way out, in Tampa, or a quarter of an acre right on Miami Beach. As long as it fits in the box, you get everything. Theirs is very, very lavish because you could have a multi-million-dollar property in that quarter of an acre. But California isn't going quite as lavish, but they are increasing it, like we said, 6 times. It's a big change. So that is the news for asset protection planning. So I wanted to put that out there because new law, and it's going to change a lot of what we do. So we can go to our final slide here. Before I take questions, I'll be taking questions. We've got a few questions from everybody, but I wanted to put this up while I take questions. This is us, RUI Attorneys. You can contact us, info@ruiattorneys.com if you have questions. We have our telephone number and we have our website, and then I'll jump in for some questions. We're getting some good questions here that I can